5, 4, 3, 2, 1, start. With the consent of the parties, the matter is taken up for final disposal full stop. The petitioners herein were granted licenses in respect of shops situated in shopping complex Sonipat on different dates full stop. The period for which the said licenses were granted has expired full stop. The respondent, Indian Tourism Development Corporation Limited, refused to extend the license period except on certain terms and conditions full stop. The action of the said respondent was challenged by the petitioners and other shop owners full stop. The said writ petitions were dismissed full stop. Appeal filed by the petitioners and other shop owners was also dismissed. Wide order dated 16th May 2008. The petitioners have not challenged the said decision and the same has become final full stop. The respondent ITDC had initiated eviction proceedings under public premises eviction of unauthorized occupants Act 1971 Act for short full stop. The estate officer passed eviction order dated 28th July 2007 full stop. The said order was made subject matter of appeal before the district judge 4th and the appeal has also been dismissed. Wide order dated 16th September 2008 full stop. Learned senior counsel for the petitioners did not seriously challenge the eviction order passed by the estate officer and upheld by the learned district judge 4th full stop. It is not disputed that the term of the license had expired before the eviction proceedings were initiated full stop. There is no renewal or extension of the license full stop. The petitioner's occupation was is therefore unauthorized full stop. Petitioners had challenged the action of the respondent ITDC in not renewing and granting fresh licenses for further period, but the writ petitions have been dismissed and the said order has been upheld in appeal full stop. It cannot be also disputed that the premises in question are public premises full stop stanza. The contention that the respondent ITDC should have first led evidence on the question of eviction before the estate officer is no longer res integra full stop. Principles of Evidence Act and the Code of Civil Procedure 1908 are not applicable to eviction proceedings before the estate officer under the Act full stop. However, principles of natural justice have to be complied with full stop. The Supreme Court examined the language of sections 4 and 5 of the Act and observed that section 5 of the Act on a plain reading would place the entire onus upon a noticee full stop. It in no uncertain terms states that once a notice under section 4 is issued by the estate officer on formation of his opinion as envisaged therein, it is for the noticee not only to show cause in respect thereof but also adduce evidence and make oral submissions in support of his case full stop stanza. Literal meaning in a situation of his nature would lead to a conclusion that the landlord is not required to adduce any evidence at all, nor is it required even to make any oral submissions full stop. Such a literal construction would lead to an anomalous situation because the landlord may not be heard at all full stop. It may not even be permitted to adduce any evidence in rebuttal to the one adduced by the noticee, nor it would be permitted to advance any argument full stop. Is this contemplated in law? Question mark. The answer must be rendered in the negative full stop. When a landlord files an application, it in a given situation must be able to lead evidence either at the first instance or after the evidence is led by the noticee to establish its case and oblique or in rebuttal to the evidence led by the noticee full stop. In the present case, there was no need and necessity for the respondents to lead evidence on the question of eviction in view of the admitted and accepted factual position full stop. Onus is upon the noticee full stop. As quoted above, Supreme Court has clarified that in a given situation the authority may be asked to give evidence in the first instance or after evidence is led by the noticee or rebuttal evidence full stop. It has also been observed in the said decision that the state officer is expected to expeditiously arrive at his decision and matters should not be delayed and prolonged full stop stanza. The contention relating to the question of waiver of notice etc. under sections 4 and 5 is also without merit as the writ petition was pending and thereafter the matter was taken up in LPA full stop. Eviction proceedings pending before the estate officer were not withdrawn full stop. The contention that the petitioners are lessees and not licensees and therefore the provisions of the Act do not apply is without any substance full stop. It has been held that the provisions of the Act will apply when the premises are public premises full stop. It does not matter whether the person in occupation is a tenant oblique lessee or a mere licensee full stop. In view of the aforesaid facts, I do not find any ground to interfere with the eviction order passed by the estate officer and upheld by the district judge fourth full stop. The main plea raised by the learned counsel for the petitioners is on the question of computation of damages and interest awarded full stop. It is pointed out that no evidence was led by the respondent on the question of quantum of damages full stop. My attention is also drawn to the order passed by the district judge fourth wherein the quantum of damages had been reduced to rupees 240 per square feet plus applicable taxes and interest has been awarded at the rate 16% after holding that the estate officer has not given any reason for awarding damages at the rate rupees 7,550 per day full stop. On the question of evidence as regards the quantum of damages, the Supreme Court has observed that although the provisions of the Evidence Act are not applicable, but the burden of proving a fact rests on the party who substantially asserts the affirmative of the issue and not upon the party who denies it, for a negative is usually incapable of proof full stop. It further held that when an application for damages is based on such grounds which require production of positive evidence on the part of the landlord, it would be for it to adduce evidence first full stop. It is apparent that the respondents were under the impression that they were not required to lead any evidence to prove damages full stop. As noticed by the district judge fourth, the estate officer has not revealed and stated as to how the market rate oblique damages were assessed as rupees 7,550 per day full stop. Rule 8 was also not taken into consideration by the estate officer full stop. District judge fourth however directed the petitioner to pay damages at the rate of rupees 240 per square feet plus applicable taxes full stop. District judge fourth has erred in directing damages at the rate of rupees 240 per square feet full stop. However, at the same time, it is noticed that some of the petitioners had in their reply filed before the estate officer had stated that they were ready and willing to renew and extend the period at the rate of rupees 240 per square feet plus taxes full stop stanza. The said statement was made without prejudice to the rights and contentions of the occupants oblique petitioners full stop. During the course of hearing, learned counsel for the respondent ITDC states that on the question of quantum of damages, the matter may be remanded back to the estate officer for fresh adjudication full stop. The statement made by the learned counsel for the respondent is accepted and the matter is remanded back to the estate officer for adjudication on the question of damages full stop. Parties will be at liberty to adduce evidence before the estate officer full stop. Writ petitions are accordingly disposed of full stop.